Chapter 5. Written Documents, Memoranda and Memorials. Most competitions require each team to submit a written document, although the form of documentation required can vary significantly. In some competitions, you are asked to provide a lengthy memorandum of submissions, sometimes called a memorial. On other occasions, you need only submit a short outline of submissions, or you might be asked to prepare a case file. Although each of these different styles of written documents serves a different function, they all have a similar purpose. That is, they force you to identify and deal with the relevant issues. Competitions that require documents of this kind will usually expect you to submit 2 documents, one for each side. The process of preparing the written documents doubles as an important step in the preparation of your oral presentations. Hence, it is worth preparing a written submission, even where it is not required by the rules of the competition. In some competitions, the written memorandum or memorial will form part of a document competition. Producing the document is usually the first task. Inevitably, putting it together will involve considerable frustration and immense pride once the task is completed. Just as your team must decide on your commitment to the moot in terms of time and level of preparation, you must also decide how much effort you wish to put into the written documents. Obviously, the more effort you put in, the better the documents you produce will be. Documents from past years will usually be available on the competition website, and it is a sensible idea to obtain copies so that you can judge the standard. The standard will be very high, but you need not feel disheartened. Remember that this is a team activity, and collectively your team will have the necessary skills. The tips and tricks of writing. The task of producing the written documents for the moot task can be highly rewarding. It can also be difficult and frustrating, but with some thought and preparation your team can sail through this immensely satisfying aspect of the competition. This section examines some of the tips and tricks associated with memorandum writing. Knowing your purpose and your audience, the first thing you need to do is identify your purpose. Remember that you are not writing a scholarly dissertation. Although there are many similarities between a memorandum and a dissertation, and your research may be equivalent to that done by master's students, your purpose is very different. Research dissertations seek to contribute or further scholarship, whereas you are simply arguing a case. Rather than analyzing the law, you are applying the law. You are not being asked to discover a new legal doctrine, but to explain an existing one. Always reduce your task to its primary purpose. Keeping this in mind will help you produce a much better document. If your purpose is not clear, and your document is beginning to resemble a dissertation, this will often be indicated by excessive referencing. Referencing is extremely important, and is covered on pages 29-30. However, it is possible to put too many references in a memorandum. Excessive referencing detracts from the document. It will not suggest that the weight of authority is on your side. It is more likely to be interpreted as showing off by those assessing the document. The purpose of your written submission is to argue a fictional case before a panel of judges. These judges will be assessing only how well your document is written. They will not be determining whether your client wins or loses on the strength of your submission. In a moot competition, you do not need to win the case to win a prize. This point is particularly important, and we return to it later in the context of oral submissions. See page 55. You need to be pragmatic. Arguably, in a real case, you are often under a duty to run every possible argument to advance your client's cause, although this too must be tempered. There is no such duty in a moot competition. The ideal document, which everyone should strive to create, will be one that also wins the case. But in a well-written moot problem, it is virtually impossible to create an ideal document. Moot problems are deliberately written to ensure that both sides have an arguable case. Furthermore, the problem will usually confine the issues to be discussed. Work within the parameters of the problem and to the expectations of your audience. This is what the judges will be looking for when they assess your document. It is sometimes suggested that moot participants should not waste their time on weak arguments. For the reasons noted in Step 5 of Building an Argument, see pages 21-2. The effective presentation of weak arguments can often be a key to success. However, the advice is not entirely without merit. Your audience will have particular expectations. The readers of your document will expect to see certain arguments advanced and authorities cited. These are some of the prejudices any advocate faces when presenting a case. The safe path is not to disappoint your audience and to ensure you deal with the expected material. As you are likely to have a word or page limit, this may mean you are unable to cover all the arguments you have been developing in your document. A good document will present the expected arguments, along with at least one or two unique arguments. These unique arguments are what will set your document apart. They must be developed carefully, and it is often easier to do this in a document rather than in an oral submission. Although ideally they should not need to, readers can flip backwards and forwards through your submission if necessary. This is not a luxury you have in an oral submission. Setting up your document. There are competition rules governing the length and presentation of the written memorandum. For example, you may be required to have a maximum of 35 pages with minimum right and left margins of 2.5 centimeters. Make sure you read these rules very carefully. If the page margin is defined in the rules, set the correct margins in your document even before you start writing. As technology progresses, this otherwise time-consuming task is made easier and easier. Most students will have access to powerful word processing programs. Learning how to fully utilize these programs will be of great benefit to you in your immediate task, that is, composing the written document, but also when completing research assignments and as you head out into the workforce. This section covers some of the important tools in your word processing program that you will need to know how to use in order to compose your written document. Using styles. There are a number of functions in standard word processing programs that you should learn before writing a single word. For example, you need to know how to style a document. This involves applying style tags to every paragraph and heading in your document. The style you apply to a paragraph will determine its font type and size, the margins, the line spacing, and many other formatting features. This function allows you to have a consistent look to paragraphs and headings, without needing to go through every line and manually change the font or check margins. You can use the basic styles set up in your word processing program for a standard document, or you can create your own style names and give them the attributes you wish them to have. Before beginning to compose your document, work out what styles you will need. Typically, you will need a standard paragraph style, probably numbered, and a different style for each level of heading in your document. This is very important for compiling a table of contents, which is discussed on page 28. You may also need a style for long quotes that are set separately from the running text. The easiest way to create a new style is by adapting an existing one. If you do this, be very careful not to change the normal style in your program. Normal is the name given to the base style in Microsoft Word. Other programs will have a similarly named style that performs the same function. It is the root of all other styles and should not be altered. Page numbering. A second function you should familiarize yourself with is page numbering. In some programs, it is simply a matter of selecting this option. In others, you will need to insert a running foot. Both are straightforward processes. However, do you know how to change the page numbering style in the middle of the document? Or can you start numbering on page 5 of the electronic document? It is likely that you will need to do both. As mentioned in the introduction to this section, there may be page limits placed on your document. It is also likely that according to the rules, certain pages need not be included in that limit. For example, the table of contents or reference list. If this is the case, those pages should be numbered in a different way. You may decide to number pages that are not included in the page limit using Roman numerals. How this is done will vary from program to program, so you will need to investigate the process yourself. Typically, it will involve dividing the document into sections. Cross-references. One of the most important and time-saving word processing skills a lawyer will ever learn is how to automatically insert cross-references within a document. Lawyers are frequently called upon to draw up a contract, and then, as negotiations progress, amend that contract several times. This may involve adding or removing paragraphs, and consequently the clause numbers will change. Each time this happens, your document should be set to automatically amend any cross-references in other clauses. It is very poor risk management not to set up your document in this way, as it is easy for human editors to overlook the occasional cross-reference. While the consequences of cross-referencing mistakes in a moot document are certainly not as dire as in professional practice, it will detract from the overall impression of your document. Table of contents. Most word processing programs have the capacity to create an automatically generated table of contents. This is another important use of the application of styles within your document. The automated table of contents function works very simply. It tells the computer to look for every paragraph styled as heading A, B, and C, for example, and to list them along with their page number. The table of contents is generally the last thing you should create in your document. Avoiding common problems. There are some potential pitfalls in word processing that you need to be aware of. A document that has been set up on one computer may look completely different on another computer. This is usually because a font you have chosen for one or more of the styles in your document may not be loaded on the other computer. As a result, the computer selects a replacement font for any missing fonts. This will affect the appearance of the text and the pagination. This problem is relatively easy to correct. You can load the fonts you need on the other computer, or use the original computer to print your document or check pagination. It is best to select commonly used fonts, such as Times New Roman and Palatino, to avoid this problem. If the problem is more complex, it may be harder to identify and correct. For example, your styles may be based on a particular style, the normal style, for instance. You may have inadvertently and unknowingly set your style to automatically reflect any changes made to the normal style. If the normal style on computer 2 is different to that on computer 1, your document may look very different and may no longer comply with the rules. For example, it may now be 36 pages rather than 35. This is a situation where teamwork is important. A good solution is to nominate one person to be the final writer on a designated computer. A similar effect can occur when you cut and paste text from another document into your document. You may unintentionally import a new style into a document when you cut and paste. You can avoid this by pasting text only, without any formatting. For example, in Microsoft Word, all the formatting features of a paragraph are contained in the hard return symbol. If you highlight the text you wish to copy and paste, but do not highlight the paragraph symbol, you will be able to paste the text into your document without the unwanted formatting. If you do need to print your document from computers other than the one on which it was created, you can avoid printing problems by saving it in PDF format. This should ensure that it will print from any computer. Referencing. Throughout your education, you will have produced research essays, and you will be aware of the importance of proper referencing. It is especially important in the context of an international moot competition. There is a real possibility that one of the commentaries you refer to in your document has been delivered by one of the judges who is assessing your document. If you misquote, or worse, plagiarize, the consequences will be dire. There may be rules particular to your mooting competition about the form of referencing to be used. For example, you may not be allowed to use footnotes. It is vital that you know the referencing requirements before you begin your research. Using a referencing style involves not only knowing the correct form of citation, it also involves knowing how to compose your sentences in such a way that you can follow the referencing style correctly. Those who commonly use footnotes or endnotes, often referred to as the Oxford style of referencing, may have some difficulty coming to terms with the Harvard system. If the referencing style is incorrectly applied, you could be referencing the application of a legal doctrine. rather than the legal doctrine itself. The consequence is that various authorities appear to be making a statement about the actual problem rather than about the law that applies to the problem. Being organized. In the course of preparing your arguments, you are likely to read and consider more than 200 different articles or texts. It is impossible to remember the details of the relevant material from each of these texts. You need to write down the bibliographic details of any resource you read at the time you actually read the resource, not at the time you write the submission. Trying to pinpoint references for quotes in your document the night before it is due is not the best way to write a submission. Unless you take a proactive approach to referencing, you will need to devote considerable time once you have completed the rest of the document to correcting the referencing alone. No matter how well you prepare, you will always need to check the references in the final draft. This is an important task that should not be overlooked. However, there is a very big difference between checking references and correcting incomplete and inadequately prepared references. Make sure that you take an organized approach from the very beginning. References are such a significant element in your final document. It may be worthwhile nominating one person in your team to be responsible for collecting references from other team members and maintaining a collective bibliography. Using bibliographic programs. Those of you who have had some experience with larger research projects may be familiar with bibliographic programs. These are programs specifically designed to help you manage your bibliographic references. They are essentially just databases. If you are unable to get access to one of the commercial products, it would be possible to achieve the same result from any standard database. Databases operate by classifying information into specific fields. For example, for bibliographic references, the fields will include type of resource book, journal article, internet, etc., author's name, the title, and so on. By entering information in this way, you are then able to determine how the information should be reproduced and change it if needed. For example, you may need to present your references alphabetically listed by the name of the author, or you may wish to list them in date order. Having this option is important because different referencing styles call for different methods of listing the information. The professional programs will have hundreds of different referencing options available for you to choose from. Select the one that complies with the rules of your competition, and much of the hard work disappears, as your program will automatically set out your references in the required style. Using a pro forma reference sheet. Irrespective of whether you are using a professional bibliographic program, a database you have created yourself, or just a list, it is very important that you give consideration to how you collect bibliographic information. Whoever is responsible for collating the references within the team will find it much easier to manage that information if it is presented in a standardized fashion. The easiest way to achieve this is to develop a pro forma reference sheet. This sheet will identify the required information, such as author, title, type of resource, and year of publication. Every team member should complete a new sheet for each reference that they read. Although its primary function is for referencing purposes, with very minor amendments, the reference sheet can be a valuable tool in other ways. For example, the person completing the sheet may be asked to rate the resource out of 5, provide a summary, or identify keywords. This information will be very useful to other team members if you decide to rotate research areas. Keywords can be used by those writing the document to quickly identify resources that are relevant to the section they are currently working on. If you are keeping any kind of electronic record of these reference sheets, running a keyword search will be very easy. Here is an example of a referencing sheet that you can copy or adapt to your team's needs. Writing style. The documents produced by your team need to be written in a clear, consistent, flowing style. This will assist readers of your document to follow the logic of your arguments and understand your case. Achieving one voice. We each have our own distinctive writing style. There may be simple phrases that we tend to repeat, and particular ways we construct a paragraph. It is very easy to recognize when different passages in one document have been written by different people. In order to achieve consistency and fluency in your team's work, it is important that your document has a uniform style or one voice. There are several ways this can be achieved while still ensuring that each member of the team contributes. The simplest method is to delegate writing to particular team members. This may be one or several people. If several people are chosen, then those people should write together. This means that as far as possible, they should all be sitting in front of the same keyboard as the document is produced. Other team members will be responsible for bringing the research and arguments to be transformed into the written document. In this way, the writers are the scribes whose job is to translate the ideas of the whole group into one document. Delegating the writing to a group of several people can lead to problems. One of the underlying themes of this book is the need to think about what you are going to do before you actually do it. Give some thought to the difficulties that may arise when several team members are acting as scribes and identify ways to avoid them. Writing with one voice will not only improve your document, but it is also a very important exercise in learning how to work together as a team. Those members of the team who do the research for the writers will sometimes face the difficult task of seeing their arguments written in different ways. If you are in this position, there may be times when you find your arguments so transformed that they are barely recognizable. How you respond to this situation will have a considerable effect on both the unity and smooth functioning of the whole team. Whatever role you are in, you are handing over some of the responsibility for the outcome to others, which requires you to have faith in your teammates. The writers must remember that they are being entrusted to prepare a group document and should not let their own personal ideas overpower ideas from the rest of the team. Presenting information to the team scribes, the team needs to think about how the researchers should present information to the writers in order to minimize potential difficulties. The information can be presented orally or in writing. Set rules about how written information should be presented. For example, you might want to list key or fundamental points that must be reflected in the document at the top of the page. Underneath these, you could provide an explanation of these points for the benefit of the writers. Unless they are confident that the explanation fits the voice of the document as a whole, the writers should resist the temptation to simply cut and paste these explanations into the document. Quotes and references should also be clearly identified. Determining a standard approach that everyone understands will avoid pitfalls, such as the writers omitting a key point. If the research is presented in a standardized way, with the key points clearly identified, then those points cannot be overlooked. This technique has a very close parallel in professional legal practice. When you begin legal practice, you will almost certainly be asked to do research for a more senior lawyer. Usually, this research will be presented in the form of a memorandum, and most firms will have a guide as to how the memorandum should be structured. The oral presentation of information is really just a discussion between the researchers and the writers. It allows the researchers to explain in more detail the importance and significance of the research they are providing. It is also a time when researchers can comment on what the writers have actually written. However, researchers should not be allowed to completely rewrite passages in the document. One way to ensure this cannot happen is to have a rule that only writers are allowed to type into the actual document. Researchers should be given a hard copy of any relevant section of the document to comment on, criticize, and edit, but they should not directly edit the master document. Structuring your document. One of the secrets of a good document, and for that matter an argument generally, is to ensure that it flows logically from point to point. It is not possible to simply sit down and write a flawless document. Considerable planning is required. Just as you might follow a map in order to go somewhere new, you need to map out a framework for your document. One way to do this is to put your ideas on a whiteboard. An advantage of using a whiteboard is that it is very easy to change the structure of your ideas until you find the best approach. Another method is to use a large piece of paper, or put each of your ideas on an ordinary sheet of paper and spread them out over the floor or attach them to a board. It can be very helpful to use a digital camera during this process. Taking a photo of your framework is a simple way of recording your work. Planning your approach is not unique to moot competitions. It is extremely important in other aspects of your studies, such as in examinations. A good examination tip is to spend a few moments drawing a quick map of your anticipated answer before you begin. Not only does this help you stay focused when you are writing the answer, but also serves to guide the examiner through your answer. If you run out of time in an exam, the concept map you have drawn should demonstrate that you know how to answer the question, and often examiners will take that into account when awarding marks. Headings and paragraphs. Within your document, you will need to guide the reader through your submissions. This is commonly done through the use of headings, where each distinct section of your material is presented with its own heading. Some competitions outline specific headings that must be used, whereas others allow you to determine your own. Ineffective headings will detract from the document as a whole and obscure the underlying structure of your argument. As a consequence, you need to take great care when composing your headings. A heading must clearly express the theme of the paragraphs that follow. It should be from your client's perspective, and ideally it will be short and concise. Different level headings must be used in a consistent manner. You must not only ensure that headings of the same level are formatted in the same way, but that their relative significance and importance are consistent within your heading hierarchy. Well-constructed paragraphs also play an important role. Paragraphs delineate issues for a reader. They also break up information into consumable parts. While there is no set length for a paragraph, it should not be particularly long. Each paragraph should contain a topic sentence. This is usually but not necessarily the first sentence. The topic sentence briefly introduces the point of the paragraph. There should only be one main point per paragraph. The middle sentences of a paragraph develop and provide evidence for the point being made. It is important that the final sentence is not simply a repeat of the topic sentence, as this will give your reader the feeling that the paragraph is going round in circles. The final sentence should reiterate the point by drawing on the evidence provided by the middle sentences. Avoiding contradictory arguments. A well-structured document will take a reader step by step to the conclusion you want them to reach. Frequently, you will do this by presenting a series of alternative routes. If the reader does not accept your first argument, then you have another argument to follow that supports your case. A common trap is to present contradictory arguments rather than alternative ones. Contradictory arguments suggest that there may be a flaw in your case, whereas numerous alternative arguments will lead the reader to conclude that the outcome you are proposing is indeed the correct one. How your document is structured will often affect whether an argument appears to be contradictory or a positive alternative. This typically occurs where you have mutually exclusive arguments. Mutually exclusive arguments are ones that cannot coexist. That is, they are contradictory. In other words, if your reader accepts proposition A, they must by definition reject proposition B. Often situations like these will be immediately apparent, while in other situations the conflict may be initially obscured by the different levels of argument presented. This can be demonstrated by reference to a relatively simple example. The example that follows relates to arbitration law, but the principles apply to any area of law and in any dispute forum. In this example, the parties involved have agreed to have their dispute resolved by arbitration. The arbitration is to take place in Australia. The law governing the contract was not expressly stated and is now an issue. The New Zealand-based respondent wants to argue that English law governs the contract. New Zealand's conflict of law rules point to the application of English law. As Australia is the place of the arbitration, we must first look at Australian law. Australia has adopted the UNCITRAL Model Law. Article 28 of the UNCITRAL Model Law is as follows. Rules applicable to the substance of the dispute. 1. The arbitral tribunal shall decide the dispute in accordance with such rules of law as are chosen by the parties as applicable to the substance of the dispute. Any designation of the law or legal system of a given state shall be construed, unless otherwise expressed, as directly referring to the substantive law of that state, and not to its conflict of laws rules. 2. Failing any designation by the parties, the arbitral tribunal shall apply the law determined by the conflict of laws rules which it considers applicable. The respondent believes it can make two submissions. It can argue that pursuant to the New Zealand conflict of law rules, English law will apply. Or it can argue that there was an implied agreement between the parties that English law would apply. The order in which these two arguments are presented will affect whether they are contradictory or simply put in the alternative. The respondent presented the arguments as follows. The respondent submits that this tribunal should apply the conflict of laws rules of New Zealand under Article 28(2) of the UNCITRAL Model Law to find that English law governs this contract. It makes this submission because, alternatively, this tribunal should find that the parties have chosen the laws of England to apply under Article 28(1) of the UNCITRAL Model Law. The arguments may have been placed in this order because the respondent believed the implied agreement argument was the weaker one. There is a presumption that you should lead with your best argument, but despite the fact that both arguments arrive at the same conclusion, presented in this fashion, they are contradictory. The reason the arguments are contradictory when presented this way is because Article 28 UNCITRAL Model Law requires the tribunal to first look to the parties' agreement, and then to apply conflict of laws rules only if the parties have not made any agreement. By first arguing that the tribunal should apply the conflict of laws rules of New Zealand, the respondent is in essence accepting that the parties have not made a choice of law. The respondent contradicts itself by then arguing the parties chose the laws of England to apply. If, however, the order of the submissions were reversed, the respondent would have two logically coherent alternative arguments. The respondent should first ask the tribunal to find an implied agreement. It is only in the event that the tribunal does not accept the submission that it needs to even consider the second. We can call these cascading alternatives, basic rules of writing. There are many good books available that set out the basic rules of writing. A number of these are listed in Part 2. You are strongly encouraged to borrow some of these books from your library. Those students who are native English speakers will have probably already learnt these rules, although it never hurts to revisit them. Indeed, this may be where non-native English speakers have an advantage. Upon returning home from international mooting competitions, some native English-speaking participants have remarked with some embarrassment on the fact that the non-native speakers spoke better English than they did. The same is true of the documents. A quick review of the document awards for the Vismoot reveals that only twice in the history of the competition has a native English-speaking team won first prize for a document. All other first prize winners have been non-native speakers. No doubt there are many reasons for this. However, complacency is probably one of the biggest factors. People from any country can become lazy when conversing in their native tongue, and are more likely to lapse into slang and colloquial expressions. Abbreviated forms of expression, such as GDay for good day, have evolved simply because we are too lazy to enunciate the complete words. Similarly, we tend to become lazy when applying the general rules of writing in our own language. If you want to do well in the document competition, you cannot afford to do this. While it is not within the scope of this book to examine all these rules in detail, there are a number of rules that are particularly pertinent to written advocacy. Sentence construction. Writing that is intended to be argumentative and assertive should be written in the active voice. Sentences should follow the sequence: subject, verb, object. If you place the subject at the beginning of the sentence, you give it emphasis. You should then place the verb directly after the subject without any intervening words if possible. The object should then closely follow the verb. Sentences written in the active voice tend to be short and direct, which is perfect for your task. The respondent breached its duty. There may be occasions where you deliberately want to understate something. For example, when presenting a weak argument. In these situations, it might be appropriate for you to use the passive voice. The passive voice reverses the position of the subject and object in the sentence. Object, verb, subject. These sentences tend to be longer than active voice sentences. The duty was breached by the respondent. Whether you are using the active or passive voice, it is important to construct your sentences so that the order of the words does not create ambiguity. You need to take particular care with the placement of any modifiers in the sentence. A modifier is a word or phrase that gives extra information about another word or phrase. Consider the following example. The food aid was ruined on the date. It was received by the Parthian Refugee Agency. In this sentence, the modifier is the phrase, by the Parthian Refugee Agency. It is not clear whether the agency is doing the receiving or the ruining, or both. Therefore, the sentence should be recast to remove the ambiguity. In complex sentences where there are multiple subjects and verbs, it is wise to present verbs in the same form to avoid confusion. For example, in the following sentence, inserting the second is helps the reader to understand the sentence easily. The respondent is responsible for the maintenance of the satellite and is liable for the damage it caused. Using words appropriately. Your ability to select the appropriate words is naturally limited to the extent of your vocabulary, or in the case of your team, your collective vocabulary. Native speakers of a language often have a natural advantage in this regard, as they tend to have a larger vocabulary than non-native speakers of a language. However, both native and non-native English speakers can fall into the trap of mismatching words. A common mistake is using an inappropriate verb with a noun. A mismatch of this sort leads to subjects doing things they cannot actually do. For example, a court may find or rule or determine, but it cannot submit. The following example is incorrect. In the shipping case, the Poseidon, the court submitted. The correct form would be, in the shipping case, the Poseidon, the court found. The subject and verb in a sentence must always agree in number. This means that a singular subject needs a singular verb, and similarly a plural subject requires a plural verb. It can be easy to spot cases where subjects and verbs disagree in number, but it becomes more difficult in sentences where a phrase has been inserted between the subject and verb, particularly if the phrase includes a noun that differs in number from the subject of the sentence. The rule is that the verb must agree with the subject, not with any intervening noun. The applicant's submission, although purportedly supported by all those authorities, is misconceived. If your sentence has two nouns joined by the word and, you should use a plural verb. You would use a singular verb if the sentence contained two singular nouns that are joined by or. If there are both singular and plural nouns joined by or, the verb should agree with the nearest noun. The following constructions are correct. The applicant and the respondent are responsible. The applicant or the respondent is responsible. The applicant or the respondents are responsible. The applicants or the respondent is responsible. Avoid gender-specific language. As a consequence of now antiquated social norms, the use of masculine pronouns developed as the default form of expression when giving general examples. This has been rightly criticized, and many official legal documents, such as statutes, must be written in gender-neutral language. Indeed, it is also a rule of most moot competitions. A common difficulty arises when you need to use a singular pronoun in a general example. For example, each member of council must present his or her documents. The pronouns his and her are obviously gender-specific and should be avoided unless you are referring to a particular person. In some cases, it is possible to use its, although this can sometimes seem clumsy. A way of circumventing this problem is by using a plural pronoun such as their, which is gender-neutral. Technically, this is grammatically incorrect if the noun referred to by the pronoun is singular. However, it does seem to be used with increasing regularity. If possible, it is better to rephrase the sentence to avoid the problem altogether. You can either recast the sentence so that a pronoun is not needed, or you make both the original noun and pronoun plural. The example above would become, members of council must present their documents. Keep the tense consistent. The tense used in a sentence provides a time frame for the action that is being described. There are 12 main tenses in the English language. If you write in the active voice, as described above, you are very unlikely to encounter more than a few different tenses. The simple tenses, as they are referred to, are the most commonly used and easiest to understand. The simple tenses are past, present, and future. The applicant submitted. Past tense. The applicant submits. Present tense. The applicant will submit. Future tense. Two other common tenses are the past perfect and present perfect. You use the past perfect tense to refer to something that happened before the action you are now describing. The applicant had submitted. Past perfect tense. The present perfect tense is used when an action is continuing. That is, it began in the past, but is ongoing, or where the action occurred at an indefinite time in the past. The applicant has submitted. Present perfect tense. As the above examples demonstrate, the past and present perfect tenses can be used to convey a similar meaning. The most important rule about tenses is not to change tense in the middle of a sentence. The tense you use should remain consistent throughout your document. The need for consistency applies to many different aspects of the preparation and presentation of your document. Editing. Editing is an invaluable part of the preparation of any document. It is inevitable that you will make errors while writing the first draft of your submission. When you consider the complexity of the writing process, this is not surprising. When you write, you are not simply thinking about the next word that is about to appear. You are thinking about the whole sentence. You are also thinking about the point you are making in the paragraph as a whole. So you are thinking about the sentences that are to come as well as those you have already written. You might have external distractions as well, such as the presence of other team members. With all of this going on, it is little wonder that sometimes the ideas you have in your head are not conveyed perfectly by the words you write on the page. Editing allows you to compensate for these distractions. Once you have written your first draft, print it out and read it carefully and as objectively as you can. Although some people feel comfortable reading documents on a computer screen, there is a risk associated with editing in this way. Authors of documents have a tendency to read what they intended to write, not necessarily what has actually been written. There is likely to be a greater risk of doing this if you read the document on the screen. When learning to study, students are often encouraged to have a dedicated space where all they do is study. We train ourselves that if we are sitting in that seat, we are there to work. A psychological association is formed. The same can occur when writing submissions, whether as part of a moot competition or for a real case. For this reason, when you begin the editing process, it is a good idea to find a place to work in that is different from where the document was written. This can help you clear your mind for the task ahead. The aim when editing is to be as objective as possible. Try to read the document as if you were reading it for the first time. Apart from correcting spelling and grammatical errors, you should also ensure that each sentence serves a purpose and makes sense. One way of doing this is to read the document aloud. Sometimes hearing your ideas out loud will prompt you to notice something you missed when reading it silently to yourself. Be brutally honest with yourself. Sometimes thoughts do not translate well into sentences and paragraphs. The idea might be good, but the expression of it in your document may not be clear or logically set out. If you identify a passage like this, simply rewrite it so that it better conveys your idea. This is exactly why we go through the editing process. Regardless of how hard you try to be objective when editing your own work, it will be impossible for you to be totally objective. It is essential to have someone else also edit the document. You can ask another member of your team, and you can also ask a family member or a friend. Another member of your team who has not been involved in the writing process will have a greater level of objectivity, as well as an understanding of the substantive content of the document. This person can advise on matters of expression, as well as the content. Having a family member or friend look at your document, one who has no idea about what you are writing, can offer you different benefits. First, this person will be even more objective than your teammates. Like you, other team members will have a tendency to read words that are not there because they are familiar with the material. Second, and perhaps most importantly, if this person can understand your argument, then you know you have expressed it clearly and logically. If your submission appeals to both those who know about the law and those who do not, then it is likely to do well. The second document. In most competitions, you are expected to submit written submissions for both sides. That is, the party bringing the claim and the party defending the claim. Some competitions, such as the Cashapp moot, require these documents to be submitted on the same date. Other competitions, such as the Vis moot, call for the second document at a later stage. In the latter situation, you will probably receive another competitor's document to which you must respond. From a participant's perspective, there is relatively little substantive difference between the two approaches. The method for developing and constructing your arguments will work equally well. Time and task allocation will be the most significant practical considerations. However, it is likely that this will be your first chance to see what other teams have been doing. Ideally, the document they have produced will be along the same lines as yours, but it is possible that it will be quite different. If it is, sit back and critically evaluate your own work in comparison to the document you have received. Be as objective as you can about which document has adopted the better approach. If you decide the other document is better, do not spend time worrying about the document you have already completed. Most competitions expect that the arguments advanced by students in the oral stages of the competition will have developed significantly since the submission of the written documents. Learn from what you have received and work hard on producing a really good second document. Preparing a genuine response. It is important to remember that you must provide a response to your opponent's submission. Your preparation may lead you to the false presumption that you can write the responding document without even looking at the submissions of your opponent. This is simply not true and would be tactically very unwise. Read and consider your opponent's arguments carefully. They may be subtly different to your own. Demonstrate to the reader that you have done this by referring specifically to passages in your opponent's document. Examine the way they have interpreted authorities. Can you challenge these interpretations? Take great care to address all the specific submissions raised. Is it good or bad to get a weak memorandum to respond to? There are 3 sorts of documents you are likely to receive. The first is a weak document. The second is one that you believe is roughly on par with the document you submitted. The third is a document that you believe is even stronger than yours. You might instinctively think that it is advantageous to receive a weak document. You would be wrong. Do not misunderstand the nature of the competition. A responding document will not win a prize simply because it is better than the first document. Just like the first document, it is being judged principally on content. The second document has the added complexity of needing to respond to the first document. And naturally, this plays a very important role in a document's ultimate success or failure. However, it is rarely, if ever, a determining factor. It follows then that the best type of document to receive is a really strong one. A strong document is more likely to challenge you to produce a strong reply. If the arguments it raises are new to you, you will now be aware of them and will be forced to respond. Responding will be easier, as the points will be presented in a logical way, which in turn will allow you to respond in a similar way. Documents that are of a similar standard are generally more comforting than helpful. Replying to a document of this kind is probably the least intensive and requires less work than responding to strong or weak documents. Responding to a weak document is the most difficult. A weak document is generally one that has very little substance, or the argument is very hard to understand. This can be due to language difficulties or just simply poor construction. Whatever the cause of the weakness in the document, you now face problems. In the first situation, do you respond to issues that are not there, but you believe should be? In the second situation, how do you respond tactfully? Do you respond to issues that your opponent missed? The competition rules and other information provided by the competition organizers will generally provide guidance on this issue. In the absence of such advice, it is best to assume that you should respond to issues that your opponent has missed. The challenge is to tactfully yet clearly distinguish where you respond to the actual arguments raised by your opponent from your response to the arguments you believe they should have raised. It is important that you do not lose your focus. Always act positively in strengthening your case. Attempt to discredit your opponent's case, never your opponent personally. One way to do this is to address concerns that you believe your reader may have. For example, you might say, "This honorable court may be concerned that the letter of the 12th of May 2001 was not a valid notice of avoidance." This approach can be very convincing because it demonstrates that you have thought very carefully about your case. It shows that you have identified areas that might be perceived as weaknesses and have addressed them. However, most importantly, you are making your point with a measured degree of subtlety. There is no attempt to embarrass your opponent. Instead, you are buttressing your client's position. How do you respond tactfully? Do not be distracted by any weakness you might perceive in counsel for the other side. Always treat them with the highest respect. As the saying goes, play the ball and not the person. If you play the person, it will not advance your document in any way and is very likely to be considered a violation of the spirit of the competition, potentially resulting in penalties. The key is to focus on presenting a positive case on behalf of your client. Adopting this approach also guards against complacency. Although you write your response believing that it is the best effort your opponent could muster, you should immediately adopt the opposite opinion as soon as the document is submitted. Competitions that have a two-stage document program generally make the documents a precondition of participation. In other words, if you fail to submit the first document, you are out of the competition. Some teams will face difficult timing issues and may have very little time to submit the first document. In these cases, rather than drop out of the competition, teams will not concern themselves with the first document competition and simply submit whatever they have at the due date. As a consequence, you should draw no conclusions about a team's ability to perform in the oral stages of the competition from the quality of their document. It is commonplace that you will face the team you are responding to in the oral stages. Do not be lulled into a false sense of security or make assumptions about the quality of your opponent's advocacy. The outline of submissions. This section is intended to include all documents that summarize the submissions. Depending on the competition, it may be referred to as an outline of submissions, a summary of argument, or even just submissions. Although there are likely to be subtle differences between them regarding presentation, they are all relatively short documents. In contrast to memorials and memoranda, referred to above, an outline of submissions is typically only a few pages long. The underlying purpose of the document, to provide a structure and explanation of your case, remains the same, but the level of detail is different. An outline of submissions needs to identify all the authorities on which you intend to rely. You would usually state the proposition you intend to make, and then simply list the cases in support. As a consequence, there is generally only a couple of sentences per paragraph. Many of the strategies for writing a memorandum or memorial apply equally to writing an outline of submissions. In particular, you should implement the strategies discussed in the section entitled Structuring Your Document, pages 36-9. As in a memorial or memorandum, you must ensure that your alternative arguments are genuine alternatives. You should write in the active voice. You should edit your outline of submissions. These are all very important steps in the process. Even though you may not be entering a document competition, the moot masters will read your written work. Indeed, They are likely to see your outline of submissions quite some time before they see you, which means that your outline of submissions will create the first impression. Make sure their first impression is a good one. The casebook. The casebook, sometimes referred to as an appeal book, case file, or trial notebook, is a mini reference library. Every authority, whether it be a case or a commentary, that you intend to refer to during your submission should be reproduced in the casebook. In a real case, the parties are often directed to jointly agree on and prepare the contents of the casebook. This cooperation is unlikely to occur in a moot competition, purely because of the time constraints involved. International moot competitions do not commonly require that casebooks be compiled and submitted. However, having one can be a considerable advantage. Frequently, you will want to cite a particular passage from a judgment or commentary. If you are in a position to quote that passage for the moot master, it will demonstrate your level of preparedness. It is particularly impressive when you are able to quote an authority in response to an argument raised by your opponent, especially if you can demonstrate that your opponent is misconstruing the authority. How the casebook is composed requires thought. It must be functional. If it takes you longer than 3 seconds to find a particular document in your casebook, it is not functional. There must be a logical and immediately apparent system to the ordering of your authorities. It must be immediately apparent because others may also be using the casebook. If the competition specifically requires a casebook, you should be prepared to provide one to both the moot masters and your opponents. Always have a couple of copies of your casebook to hand in case you are asked to provide them. But unless asked, you do not need to volunteer a copy. There are a number of logical sequences that you might consider. You may collate the authorities alphabetically. Although this is logical, it is not ideal. There are too many variables. For example, if you are including a commentary, should it be listed under the title or the author's name? A better approach is to order the references in the sequence you intend to refer to them. Separate each reference with a divider in tab. Then number each tab. This is a very straightforward and effective method. However, it is not enough though to set the order once and then just blindly follow it thereafter. You need to develop an awareness of where all your references are in the casebook. You need to know which decision of the International Court of Justice is under tab number 3, for example. Without this knowledge, you may get into difficulty if the moot masters take you away from your intended structure. The way to learn these skills is discussed in the section headed Using Case Materials below, see pages 77-9.